Welcome to Law Subscribed. This is your dedicated news source for all things subscriptions and the law. My name is Matthew Kurbis. I'm the subscription attorney, and I believe subscriptions can help bridge the access to justice gap and incentivize attorneys to modernize and scale their practice like never before. In this episode, I interview Erica Payne. Erica is the founder of Taproot Law, a law firm that is doing things differently. Motivated to start her own law firm based on personal experience working for billable hour firms that didn't allow her to practice law and live a healthy life. She is now serving clients using predictable fees and is getting ready to launch a subscription model as well. Longtime listeners know I've been releasing videos of my podcast to all of my Substack subscribers. Go to lawsubscribe.com and join the Substack using the form on the homepage. I'm speaking at ABA Tech Show in Chicago this February of 2024, where I'll be presenting on generative AI and the subscription model and podcasting for lawyers. Register for that at techshow.com. Thanks as always to my sponsors, 650 and Gavel, links to both in the show notes, more on them later, and remember to use the code LAWSUBSCRIBED when signing up. It lets them know you found out about them from the podcast, you get 10% off, and it really supports the show. Another way to support the show is to share it with someone you know. This podcast is for educational and entertainment purposes only, and nothing said is legal, ethical, or financial advice. Without further delay, here's the episode. Erica Payne of Taproot Law, thank you so much for joining me on the Law Subscribed podcast.
Thanks for having me.
So we've had a chance to get to know each other, and I've gotten to know somebody working with you on your team, which we'll get into in the near future. But for those of my listeners who are just hearing about you for the first time, go ahead and introduce yourself to my listeners, please.
Thank you. I'm excited to be here and have this opportunity. Erica Payne, I've been practicing law for 12 years now. I have 10 years of experience in a traditional law firm. I was hired there straight out the gates at the age of 25 and eventually learned it wasn't quite for me. And I have since launched my own business, Taproot Law, that is a progressive business, and we are largely experimental. We want to put ourselves out there, fall on our faces, and do things that lawyers don't usually do to better our practice, better our culture.
Yeah, that was why I was so glad that we found each other, because I also have a very experimental law firm where I'm just kind of learning as I go. But I'm just one guy, which is why I love to have people like you on the podcast, because while we both agree the billable hour is terrible, we are like independently trying to solve this in our own unique ways. And so tell my audience just a little bit more about what makes Taproot Law so unique.
Well, Taproot Law is just basically, we're providing services in different ways. And so normally traditional law firms try to increase your hours, just, basic, increase people, increase hours. And so Taproot is really looking to solve problems by process. Our goals are really to eliminate bad process, create a space for custom advice and expertise, and that clients are really paying for that expertise. And that's really the only variable from client to client. And so basically, I was motivated largely by wellness and recognizing that the culture of a traditional law firm did not provide for the wellness of me, my team, and my clients. And so Taproot was born.
Now, certainly you didn't just, maybe you did just decide, I'm going to go off and do this Taproot Law thing. Was there something that happened in your professional career that made you want to do this?
Yeah, actually, I got sick. I don't know if that is a professional experience that I had, but it certainly affected my life. I became partner after practicing about 5 years in the firm, so I was a little over 30. And then about a year or two after that, I started getting sick in every which way. And so sick that it sent me to Mayo Clinic in Minnesota, University of Michigan in Ann Arbor. And the doctor at Mayo Clinic said, "We don't know what's wrong with you, but we certainly know that your environment, especially at work, is impacting how you're able to heal from whatever's going on." And so basically the doctor challenged me to go back, take a look at my life, specifically take a look at my firm life, which was largely controlling my life, and see what I could do I went to college to be a graphic designer. So I kind of took this as a challenge, I think, internally to design my environment differently, to finally take control of my environment, which is something that associate attorneys, anybody working in a law office is kind of discouraged from doing.
Yeah, and I'm so glad that you're coming on the podcast, being transparent about that because I do not think, and I think some of the data shows, although it's all anonymized, that lawyers are suffering from several wellness issues. It's why there's been such a
Mhm.
push in the ABA and other organizations to say, "Hey, we have to start caring about wellness." But there's just this thing called the billable hour that makes it really hard to be individually, let alone clients, right? Like individually
Mhm.
well. It's safe to say you were billing time when this incident happened with you, right?
Yeah, and I have looked back. A lot of what I've done to get me here is kind of look back and what has happened that got me here. And so I do look back at how I was initially trained, and the billable hour is kind of the hub of the law practice, especially if a law practice doesn't have common vision and mission, then the center of it has to be the billable hour. It has to be making money. Like, and there might be other conversations about how that's done, like reputation in particular, tradition, those sorts of things. But generally, that's the main focus. So I recall coming into the first firm that I worked in where I was for 10 years and being taught about how they treat the billable hour. And as I've talked to lawyers over the years, there's, a specific culture that a firm creates around the billable hour. But it is largely, it can be a little bit unique, but I think the flavor is generally the same from what I've heard. And so as I have looked at the timeline that I've put together, I find things like overwhelm, decision fatigue, lots of confusion that was created by this hub called the billable hour that was so stinking confusing.
Mm.
So at my firm, I had 8 partners when I joined, maybe 7. So I had 7 bosses, and they encouraged experimentation in not the way you and I describe experimentation. It was work with all of these people to see who you like working with, what area you like to work in, not necessarily how you like to work.
Hmm.
And so, as a result of that, I had 7 different bosses who build 7 different ways. And I tried to make like rules, like what rules can I follow so I can navigate these 7 partners and all their different ways of doing things and how this client should be treated differently than this client because of all this history that I didn't know. And I couldn't do it. And there were times where I tried to like have several partners create consistency when I found patterns. And there was reluctance to create a rule because people couldn't agree on a rule. And so that left me and the other people who were supervised by partners really confused. And so every bill I had to send out, there was just substantial confusion around like, all right, who's going to be criticizing this? And then on top of that, so what I was told was as a young associate, I should focus on collecting half of the hours of my day. And the firm culture was, hey, we live in a rural place. We're not going to make millions of dollars. So, like, you don't have to work as many hours as they do in the big city. And this is where I think big problem lies. So they put in my head like 4 hours was the amount I should collect a day, but I didn't understand what the word collect meant and all of the things that went into that. So it was completely beyond my control. I had no control. And lacking control is another thing that turns you into like confusion, apathy, all sorts of things that we're seeing from young lawyers. So I guess where I see this now is like they were telling me to bill 4 hours a day, not to work too much, but then my time was getting cut. So the partner would then like, I am not saying I would only bill 4 hours, but even if it was more hours that if I was billing more hours, they were getting cut by a partner. So a partner so I was already billing at a lower rate, which is operating under the assumption that I am not as qualified as the partner. And then so I was already getting discounted on how much I collect. Then on top of that, I might have like 8 hours that I would bill in one day, and that might be on 3 different projects with 3 different attorneys, and different attorneys would be cutting my time. But I would never be able to see that or really give it meaning. At most, I would be informed when an attorney would stop at my door and say, "Hey, I cut the bill this amount." And early in my days, they would sit down and talk with me about why that happened, which just made more decisions for me in the future. But I could not quantify how much my time was getting cut when it's a little piece from here, a little piece from there. And then all of a sudden, I thought I had 2 days banked of billable, collectible time, and I might actually only have one. So, how this then, as my career progressed, I wanted to make partner because obviously that's where the money is. When I first started, they wouldn't give me any information about the books. And like this is really common of any traditional practice. And I'm not necessarily attacking my former boss, but
Yeah, let me just chime in here just briefly, and then I'll let you
yeah.
continue. Is I think this could be a really good episode for maybe law students, even because
Yes.
I certainly didn't understand this when I was going to work at a law firm, and I didn't really have to bill time until my second firm, and then we exclusively billed time at my third firm before I went off to do my own thing. And
Hmm.
so I do talk about this a little bit in my continuing legal education talk on the subscription model, but basically how much time you work at the office is not the same thing as how much time you bill in your timesheets, which are hopefully digital, but not everywhere always, which is different than the amount that a client is willing to pay, which
Right.
sometimes lawyers try to, the partners before they send the bill, they try to lower the bill before they send it so that the client is more willing to pay it, which of course really just means that the way that we practice law is backwards and nonsensical once you actually figure all of this out. So, yes, very common,
Yes.
super common. This is not just supposed to represent Erica's experience, listeners. This is a super common experience. So, Erica, with that, I'll let you continue.
Yeah, and so I think you make a good point of like, there's this understanding of what the client will pay, but there's also this mindset of the attorney and there's so much experience and things going into why they're discounting that bill, which probably has more to do with their own insecurities than anything, but it's affecting me. And so that was the standard I was given to make partner. And I was told a certain collection amount based off of so many hours a day. And then I fell short. And I was told, oh, we told you the wrong number. You have to collect more. And it was devastating to me to have that happen of just like, I eventually did, I think I did collect. I need to back this up here. So yeah, they told me you need to collect X amount to become partner. I did that and it was short because they didn't even understand how much I needed to collect. And so that I think I did become partner, but that experience in general was just like, whoa, what is going on here? I couldn't that I think that was the first time I took a step back and I was like, they don't know their numbers. Like, what are the numbers here?
So all of this experience was not, it was not good for you, not just metaphorically, but physically.
Mhm.
And what was that? That was while you were still at this firm. So what has it then been like to create a practice where you can worry about your own wellness, let alone your clients?
Yeah. Well, to create it has been difficult. I mean, we all, like me in particular, I can stretch my brain to think about things differently, probably more than most. But I have been trained in a traditional practice, which means I'm predisposed to look at solving problems a certain way, even if I think that it needs to be changed. And so the team and that I've been working with, we've been, trying to navigate some of these issues because you can't. your brain does not start on a clean slate. And so there's been a lot of movement and a lot of work and trying to do exactly what you were saying. Like once you do the math one way, you see how traditional law is kind of working backwards. And so we've been like taking everything apart and rewrapping it and putting it back together again. And it has been amazing. I like getting up in the morning now. I am no longer sick. I have fully recovered. And my doctors were right. They were absolutely right. Even though the initial cause was not from my law practice, that experience enhanced all of my symptoms. It took up a lot of my brain space, and I had nothing left to heal. I had nothing left for my family. I had nothing left for my sweet dog. And and so now I'm in a position where I don't feel like I'm just subjected to the environment that's around me, and I have control over what kind of stresses I'm exposed to and what kind of things I want to deal with. And I've never been happier, which is funny because there was so much discouragement from a lot of people in leaving traditional law because it seems very secure. It's a known quantity. People seem to want it. And it was nothing like I was told to fear. And it took me a long time to leave my practice because of that fear. And with anything in life, there are trade offs. It's not without difficulty, but the difficulty has been pleasant to work through, at least in the end. And I I strongly encourage younger attorneys to seek out these alternatives because there are networks developing that will support this. So even though traditional law might be well known, there is a group of people developing a model of different ways to do business. You are one of those people. And I just hope that people put wellness and their ability to last in this career before maybe their notions of security kick in.
Yeah, and while these newer models of practicing law develop, it will certainly be less profitable at first than billing time. But you have to think about what's the opportunity cost and what are you sacrificing, and it's oftentimes mental health and physical health.
Yeah, and the numbers aren't lying. Like, I'm finally, because like you said, we have to, like, unwork it and rework it. I'm finally seeing the economics of what I'm doing, and I can compare. So my projections are that I can make twice as much as I could make in 1 day of trial by changing my process.
Mhm.
That's 1 day of trial, like a 10-hour day of trial, which is the most extreme stress you can be in. And don't get me wrong, I love it. I'm not gonna do it anymore because it is it's not a right fit for me and my body, but I love being a litigator. It's fun, but it's a lot. And so what I'm saying is like I'm taking like 200% stress level, I'm lowering it to 20 and I'm making twice as much money. Those are what my projections are right now.
And you've got something really cool with segmented flat fees for litigation because I want to talk about that. We're going to get
Mm.
there because my listeners at this point they're like, "Where's the subscription talk?" Well, let's pull back the curtain right now. Taproot Law is not currently using subscription, though there are some plans which we'll talk about as well. But it's how you're doing flat fee work and also how you're marketing and truly have designed your firm as human centered. And so if you go to taprootadvocates.com, you'll see that that a lot like my law firm website, you could click a button on the first page and you're sent to Calendly to schedule a call, which is great. But also you'll see human-centered legal advocates as the tagline, and you go on to talk about how Taproot Law is human-centered law firm. Is it as simple, Erica, as just trying to not bill by the hour and voila, you're human-centered, or does a little bit more go into it? Tell me what you mean by human-centered legal advocates.
Thanks for asking that question. Yes. So a lot of it goes into eliminating the billable hour, like
Mhm.
we just talked about, and some of this is coming, I guess, clearer in my head through this conversation of it's impossible for the billable. if you have no mission, you have no values other than to make money, the billable hour is the center of your business. And so largely eliminating that has been a way that we've been human centered. So another way of looking at being human centered, a big buzzword these days, is user experience. So what I try to do is put myself into the shoes of my client and be like, what do you actually need? What do you want from me? And so one of the ways that I've done that, which I think kind of aligns with a lot of things that are similar with subscriptions, is our coaching service, where I've tried to make absolutely everything uniform in process and have the only thing that's different is the actual coaching session, the half hour time in which I'm one on one with a client and I'm actually giving them advice to move their issue forward. So that is the service that we started with. And then we are moving on to other services. The subscription service that we are working on is called Law by Design. And I have learned how to use Canva and I have created all sorts of graphics. And I've been giving them to my lawyer friends periodically to test out. But basically, like, for example, one of my best friends is a divorce lawyer. And sometimes she needs to talk to somebody about estate planning, which she doesn't do regularly, but she needs to advise them to go get estate planning. And so if she had a tool about these are the basic steps of estate planning that are pretty much uniform wherever you go, she is able to have a tool that decreases uncertainty for her and her client. And so that we want to increase certainty. And so we are doing that through Law by Design, having these graphics available online that people could pay, lawyers in particular, could pay a subscription service to use these in their practice.
So that is a subscription service for lawyers to use in their practice for their clients.
Yes.
Very cool. That's
Yeah.
great.
So I have talked to other professionals like realtors who are also interested. So there's some also plans for expansion in the future.
When I went solo, I pivoted from mostly litigation to a transactional only practice. I did not have a database of documents to automate. That's why a business and employment legal document database and automation tool like 650 is super useful. I can rely on the quality of the documents in 650's database since they're putting excellent legal minds to work curating and updating their documents and automations over time. When you're not billing by the hour, outsourcing and efficiency matters, and 650 can help you scale your practice to get high quality documents drafted in less time. Use the code LAWSUBSCRIBED at 650.com and when being onboarded to get 10% off. If you're not a business and employment attorney or you have your own documents that you'd prefer to use, then my next sponsor, Gavel, is the automation tool for you. Gavel allows you to build shareable, client-facing workflow and document automations. In other words, Gavel helps you create a legal practice where attorneys can monetize the value they bring clients in productized form and scale via subscriptions and flat fees. Use the code LAWSUBSCRIBED at gavel.io to get 10% off an annual subscription. There's no one right way to automate and scale your practice, but with one or both of my sponsors, 650 and Gavel, you can take your subscription law firm to the next level. Links to both in the show notes. Now back to the show. Yeah. I mean, what a great use of the subscription model, because if lawyers are also, and I mean, my opinion is when lawyers stop billing time and they create predictable recurring revenue, then they can more easily appreciate their spend on resources on the subscription model, which is how most other software services, technology, even some of these fractional virtual assistant type services are like on a subscription. And
Mhm.
so seeing another resource out there for lawyers on a subscription, I think makes a lot of sense and comports with the mission of the podcast. So, I mean, that's fantastic to hear. And something else I want to pluck out is your mention of UX, or, user interface, which is another startup term that's come up in the podcast now. I don't think, I can't recall. I'm doing so many of these podcasts now, it's hard to keep track of it all. But I don't think we've talked about UX yet. And
Mhm.
but we've talked about a lot of other aspects of being a startup, and
Mhm.
that is such a phenomenal thing that there's a lawyer out there, you, who is thinking about this type of thing that businesses think about that law firms simply don't think about. Because most law firms are like, hang up the shingle, or we have the practice, we have the brand name, a bunch of old white guys, as the brand name. And people come to us when they have legal problems, and we're just going to help them. And who cares what the UX is? Because guess what? You have legal problems. We have a monopoly on legal services. So you have to pay us whatever we charge. And it doesn't matter what the interface is because you need us. You don't have a choice. So like just your interest in focusing on that is thrilling to learn. And part of that is, and we mentioned this at the start of the show, is somebody on your team, Ann Burke, is a PhD, and she's a qualitative researcher, which is super
Yeah.
interesting you're really focused on that. So like tell me why even bring someone like Anne onto your team?
Yeah, this was a huge investment that I took a lot of time to consider is that we are doing things in such a different way at Taproot, and they are working. They're really working. And I want to be a model for other attorneys to use. I want attorneys to have a well life, and this is one way to do it. And if I can give a model out there, I'm going to. But what I also know is that as soon as I'm like, this works, and this is like, here's my argument for why it works, I'm just another lawyer making an argument.
Mhm.
So I wanted to bring Anne in to have some research behind this and to steer what we're doing. I want to be better. I want to keep getting better. And so with having with us, we're able to gather more data with client feedback. We're doing a lot of questionnaires and surveys. And then we have a regular review process, which we're using that feedback to see what the clients actually want. What is their experience actually like with our technology, with our people? And we're actually using that. A perfect example of that is that we're in the Upper Peninsula of Michigan, and it is a lot of land, not a lot of people, but we feel very much like a community here. And when we started our firm, we had a remote receptionist from one of the larger companies. And every time people would call, they would be like, "Are you in the UP? Are you a Uper?" And they wouldn't wanna pay us because our model is, pay in advance. And so there was this insecurity because they didn't recognize the accent that was around.
Mhm.
And so we found somebody locally who was able to step in and be a remote receptionist. So we're not using the big company anymore. We don't have their systems, but I do have a person who sounds local and that people can trust. And that is an exact reaction of the feedback that we got. So that is what we intend on continuing to do throughout the life of Taproot and then share that data with all of you so that we can make a better practice.
And I mean, really, like that big company that provides remote, virtual assistants or remote receptionists, like they should have somebody hired from your area and like supply that person to you. Like that's a huge market opportunity for them based on what your
Mhm.
research is showing. So like that research is not just valuable for lawyers practicing law at law firms, but for service providers to law firms. Like super useful right there. Like incredible lesson, right? The local
Absolutely.
dialect, like that is huge. That's a big takeaway right there. Something else that you're doing, which I thought is really interesting and worth mentioning in the time that we have today is how you have set up your law firm in terms of like making your employees on equal footing, regardless of I'm top dog named partner and so I get the most amount of money. So you're also challenging that status quo. Tell my listeners a little bit about what you're doing there.
Yeah, this was one of the most exciting things I did was make us as equal as possible. And so we are all paid an equal livable salary as a base, and any profits we have, we will all share. The traditional model is that as a small business owner, the lawyer is supposed to take home all of the profits. And I never quite understood it because what that meant was that when somebody made a mistake, I was late at night making my family wait for me. I had all this additional burden on my shoulders. And the moment that I made them equal financially, It was the moment I slept really well. And I was like, "Oh, this isn't entirely my burden." The state of Michigan prohibits lawyers from entering into business with non-lawyers, which is pretty practical. But the problem with that is that it stifles innovation, creates a monopoly, and because we're not getting different brains in there and into a law boardroom, basically, like we would have at a bank or other businesses like that. And so by eliminating, by making everybody equal also, it they came to the table and brought more to the table. They had more of a stake in making Taproot what it is. And that has all played out very well. It is it was at first I made the decision that we should all be equal as far as base salary. And spent a long time contemplating what to do about this profits thing because there will be more work for me going into this, especially at the front end. But what I see this is exactly what you said, like when you create a subscription service or any service like this, when you have a ton of work on the front end and then you need somebody to run it. And so despite the fact because of this business that we're creating and that I was able to mentally get over the prior training that I had, like the capitalism type of like, this should be mine. And I just let it go because I just saw this as one project that I cannot possibly complete without every member of my team. And so we have, by making everybody equal, what I did is say, your basic needs are no greater or less than mine. In 2023, we meet all of our basic needs by cash. I cannot possibly say that the person who serves as a paralegal on my team, that her basic needs are less than mine. And I couldn't continue living that way. And that is how I looked at it and made that decision pretty easily. And so we'll be exploring through our blog how that's been working out. We just had our first experience with maternity leave. We made it through. We'll be talking about that. That was really exciting and stressful. I mean, it was something new, but we made it through and we have some excellent stuff to share with people.
Yeah, I like so I've heard of some other law firms that are starting to do something similar. Now, I've not heard of the sharing in the profits equally across the board. I think that's something unique to Taproot Law, but I've definitely heard about certain law firms that are changing and disrupting the status quo of the law firm business model when it comes to employees and how they're paid and how they're compensated.
Mhm.
Every single one that I've heard of is a woman founder or
Oh,
women
wow.
founders, right? So like I
Wow.
wonder maybe that's something that law firms are missing that are doing it the traditional way, or if there are women on the leadership teams at these law firms, that it's still completely dominated by men, usually white men, which brings me to a question I like to ask all my guests. I usually save it towards the end, and I promise listeners we'll get back to the litigation flat fee stuff. But we're on topic, we're staying on topic. So, like if you've listened to the podcast for a long time, you know that ABA data in the profession has shown that women, even though they're going to law school more than men, they are not leaders at the large, big law firms. Or, if you look across the profession, there are fewer law firms that are where women are leaders at the firms. And similarly, while not at quite the same quantity as women, attorneys of color, there's more of them going to law school than ever before, coming out. And yet with this podcast, and like we just talked about, it is women and attorneys of color who are breaking the status quo and doing the innovative things, usually killing the billable hour. So, Erica, my question for you is, why do you think that is?
Well, I think that so the original systems were created by white men. And I think that we see this in government a little bit is very difficult. Like when we want to change our constitution, it's difficult. So you, and what you have is a changed version of something that you already had. And so how I see this is my experience was that I was brought into a system that was created at a different time and place. And that system has never been rehauled. And so it is extremely uncomfortable for me to work within it. And so I determined that I could no longer work in this broken system because it could not be repaired. And so I sidestepped it. I'm trying to sidestep all of this stuff. And as a collaborator, that's what my nature is like, all right, this system isn't working. I tried to save it. I like make it work in every way I could. And I'm concluding this is not a good place to put my time. And so I think women are trying to find alternatives to that because, all right, women, we can make it in a traditional law firm. We can do it. We can do all the sacrifice that it needs to do. Now the question is, should we?
Yeah.
And I think user experience, feedback, and when, a lawyer is a user, a paralegal is a user, we need to look at those things too. And the system doesn't allow those people to use those systems very freely or to be very free within those systems. And so women, I believe, are finding different ways to define freedom within our jobs.
Yeah. Yeah. Well, you put it so well. This is why I'm so glad I'm not the one who has to mansplain things. Not that I ever should feel like I have to do that, but like, this is why I'm so glad to have you on the show and frankly, mostly women on the show. So, because you also just do a better job communicating it than I ever could. So, really thrilled about that. And it's a great takeaway. And for the attorneys who are men who are listening, we're not going to like wave you off. Like, this is your opportunity to bring in women as
Mhm.
whether even if they're not lawyers at your firm to do something like what Erica's doing and really give them a seat at the table so that they could help drive, decision making.
And recognizing that,
No, no, please
recognizing,
continue.
yeah, it does. For men, recognizing that you have a certain experience and that it is difficult to stretch your brain to like see a different one. Because I think that, like, after going through this experience, I talk about stretching your brain, but really what I'm talking about is being able to see the user's experience, being able to challenge your own bias. And so having women there will definitely help that process. But it is I challenge men to surround themselves with women who and others who will help them stretch their brain, challenge their bias, because it'll allow them to move more fluidly with where I believe the practice of law is going.
And, selfishly, if you want to potentially make more money and do less work, like this is like it's a lot of upfront work. I had one guest on the show say to set up their automations took them 3 months and 30 minutes because they put it off for 3 months. And then finally, when they did it for 30 minutes, now this automation runs. And
Oh
so,
my
like,
gosh.
right.
Yes.
So, if you can't do it on your own, bring in people that will, I like that term, stretch your brain. And
Mhm.
you just people who are different than you, whatever that's gender or background,
Mhm.
cultural, economic, race, what have you, right? Now,
Yeah.
but I gotta steer the conversation back because a lot of my listeners do tune in for like the nuts and bolts of like
Yeah.
how do I not bill by the hour? So Erica, you have segmented flat fees for litigation of all the things. That's where people are like, well, I can't not bill time in litigation. Like that's like the one place where the billable hour will continue forever. I of course disagree. And obviously you do too. So how was it that you came to that? And yeah, like to the extent that you're able to share how you're able to do that segmented flat fees, how you're able to do the segmented flat fee pricing, like, please do share with the audience.
Yeah. So I have done segmented flat fees in a couple different ways. One in administration cases. So we just actually published those, or they will be published, our fees for that kind of work. But it actually did originate with this litigation flat fee model because when I left traditional practice, I was a full time litigator. And so I knew the ins and outs of what to expect on like any real estate litigation case. It's pretty much the same. So the first thing I do is I found as many patterns as I could. And then I broke down the litigation process into steps. I did the same thing with administration. Like, where can you find that this chunk of work is done? And if you're in a traditional practice, if you start being a little bit mindful, you'll feel it. you'll feel when you're changing gears. So I can give an example of like the first couple steps. So once a lawsuit is filed, then I just did a flat fee because for an answer, counseling the client, and getting through to the pretrial conference. That is a really good first step of like, all right, all the pleadings are in order. This is where we go. So I was able to charge a flat fee and be like, that's what that work is. And if I added like an upcharge if there was more than one person, but ultimately it didn't change. My work didn't change if I had to answer a complaint for one person or five family members. And so I was able, there was, there were no variables. So there's no excuse not to have a flat fee there, in my opinion. And so then I was like, all right, the next step is discovery. And that's so difficult. How do you figure out how much money you're going to spend in discovery? And so I went to my coaching. So every step starts with coaching. You sit down with the client, you advise them what you believe things will cost. You spell it out on what your recommendation is. I think we should do 5 depositions. And then the client can say, I don't want to pay for that 5th deposition. That's not important. And the lawyer has an opportunity to be like, well, it proves this element. So we need that. And so at the beginning of each segment of the case, you sit down, you coach the clients, and you have an agreement. You have a meeting of the minds about what that is going to cost for that. And then you move on to the next stage, pretrial. Then you move on to the next stage, which is trial. Then it's post judgment, and on and on. And so by finding little buckets, you can break that up.
And it's also important to mention that in Michigan, you like Illinois and several other states, you allow for unbundled and limited scope legal services, right?
Correct.
Right. So, I mean, I know there are some jurisdictions where that's like not an option, but, look at your local rules, look at your
Mhm.
code of conduct, requirements, and find a way to do something like what Erica's talking about. Because, you know, I had my own version of how to do subscription plus flat fee for litigation, but I think that the segmented approach that you're talking about can work without subscription. Though, of course, my recommendation is if you could get them paying whatever it is, $20 a month, $100 a month, throughout the pendency of their case as well, then if things do end up taking a little bit more time, maybe than you initially anticipated, you're still being compensated something for that, and your clients are more likely to reach out to you because they are paying you every month, and so they will keep you, and you will want them to stay subscribed, so you'll keep them on top of their case in litigation.
Yeah, I think that if I were launching this today, and I'm not launching it right now, but if I were launching it today, I would definitely include a subscription service for like a helpline and different things like that. So there would be services that would be subscription that would coexist.
Yeah.
And I guess to your point on the subscription service and how I always try to describe it is I have 2 rentals and I always am like, I'm trying to find another rental, like a bucket. So I because it's just passive income that we're chasing. And so like if I can get another rental in the form of a subscription, that's bonus for me. So I'm trying to find ways to do that as well.
Yeah. Well, keep tuning in to Law Subscribed, where you'll hear about all other ways that lawyers are doing it. Maybe one of them will inspire you. That's great. So as we start to round out here, I got to ask the question of the day, which is, have you looked into generative AI or any of these artificial intelligence tools for lawyers that are starting to come onto the scene? Like, what has been your experience with that? Or are you still kind of, being super, super cautious in that space?
Well, I spend a lot of time experimenting with different technology. I'm very cautious. I I think that there is a spot for it. Right now, I'm working on getting all of my systems working very reliably using the least amount of technology and the most effective methods to get my clients engaged. And so I'm not there yet. I do think that the next phase of technology and design is going to be user experience and not necessarily adding on all sorts of technology. And so some of those things may come into play, but it is something that I am more cautious on because I used to think that all sorts of legal technology could solve all of my problems. And now I'm realizing it had my entire team trying to learn and provide information in the exact same way, which is impossible. And to that point, clients all learn differently. And so there is a place for that probably in my future, but it will be limited.
Mhm. No, I think that's a great answer. And while we're on the subject, even if it's a limited tech stack, we know you're using Canva, we know you're using
Mhm.
Calendly because we see it. You could click to it on the website.
Mhm.
Any other pieces of technology that you're using that you like that you'd recommend other attorneys should think about?
For me, so we try to figure out which tools each team member uses. So I actually try to get off of like these are our standard go-tos. For me, I like taking notes on Evernote. It works great for me. I am much more visual. I take pictures with my phone and I lose notes all the time. So it keeps them all in the same spot. We do Adobe Pro is a go-to and putting documents together. I don't think I could live without that tool. But I spend most of my day on Canva and in Evernote.
Yeah, yeah, and the e-signature aspect of Adobe Pro 2 is a nice additional feature for
Right.
e-signing. Yeah, yeah, that's one of my tools as well. I don't know what I would do without a PDF editor of some kind. It's like you wouldn't think that like a PDF editor and e-signature tool are crucial to an innovative law practice. Okay, but they absolutely are. Like it's part of my CLE.
Right, right. And I just remember the first time I tried to even use an electronic signature. I mean, just like where I had like a photograph of my signature and put it on, and my partners were upset about it. I was not allowed to do it because it was a weird technology that they weren't used to. And now it's so common. We need those things. And COVID helped us, I think, realize that we really need them.
Yeah, yeah. So with that, Erica, my final question for you is a hot dog a sandwich and why?
A hot dog is a sandwich because there are 2 pieces of bread, in theory, especially if you break the bottom of the bun, and there's stuff inside. Seems like a sandwich to me.
All right. If people wanted to get in touch, what's the best way for them to do that?
You can find me on my webpage, taprootadvocates.com.
All right. Erica Payne of Taproot Law, thank you so much for coming on the show.
Thanks, Matthew.
And that's our show. Thanks again to 650 and Gavel for being sponsors. The best way for others to discover this show is for you to share it with somebody you think would find value from it. Follow me on LinkedIn since that's where I'm most active on social media, and click the bell towards the top right of my profile to get notified about all of my posts about this podcast and everything else I think is valuable for you to see. To get in touch, message me on LinkedIn or email kurbis@lawsubscribed.com. All links are in the show notes. Until next time, this is Matthew Kurbis with Law Subscribed.